Let me introduce first, directly to my right, Andrew Carswell. Andrew Carswell is the delegate to the U.S. and Canadian Armed Forces for the International Committee of the Red Cross, which you will often hear us refer to as the ICRC for short. Carswell also served as advisor for the ICRC's Unit for Relations with Arms Carriers in Geneva. He has served on the ICR operations in, listen to these countries, in Jordan, Syria, Afghanistan, Rwanda, South Jordan, and Zimbabwe. All real vacation spots. Previous to the ICRC, Carswell served as an officer in the Canadian Armed Forces and he worked with the Judge Advocate General's Office, which is the senior lawyer for the Canadian Armed Forces, specializing in military prosecutions, international law, and legal training. He also worked as a criminal prosecutor in Calgary, Canada, and as a clerk at the Court of Appeals of Alberta. He's authored several publications, all of which I have read and can vouch for their quality. On the law of armed conflict, Carswell received a BA in Politics and History from McGill University, a law degree from Cardiff University, and an MA with distinction in International Law of Armed Conflict from the University of Geneva and the Graduate Institute of International Studies. To his right is Professor Matthew L. Duffin, who is an Associate Professor of Legal Studies at Utah Valley University, here locally with us. We're glad to have him come visit us. Professor Duffin previously served as a military judge advocate for more than 20 years in the United States Air Force. Previously, while he was in that military service, his work included serving as an Associate Deputy General Counsel for International Affairs at the Department of Defense during the Iraq War. So that's one of the top legal dogs in the Department of Defense on those issues. He was also an assistant professor at the United States Air Force Academy and developed cases against the detainees in Guantanamo Bay, which gives him a special expertise with us here today. Professor Duffin volunteers also as a small claims judge pro temp. He received his BS and JD cum laude from BYU Law School, as well as an LLM in military law from the Army's Judge Advocate General School. So we would like to welcome them here with us today. And we're going to do this a little bit differently maybe than some panels. What I am going to do is I'm going to give them some questions to discuss, maybe in a back and forth way. They may have different perspectives on these questions, and we'll go for a short time, but we want to eventually get to your questions as well. That's very important to us. So let me start by just asking both of you, and Andrew, we'll start with you. What is it about your experience that I've just read that makes you, that gives you your connection with detention and armed conflict?
Okay. Eric, thanks so much for putting this whole thing together. Thanks very much to BYU. Thanks to the Kennedy Center. Corey, very much appreciate your efforts in bringing this together. I work for the ICRC, which is the part of the International Red Cross and Red Crescent movement that deals with armed conflicts and other situations of violence. And that means we have a dialogue with armed forces around the world, both the states and non-states, in relation to their obligations under the laws of armed conflict. So from that perspective, we're sort of the guardians of the laws of armed conflict. So, very roughly, our organization does three things. We do protection activities, so we visit with detainees, for example, to make sure they're being held in accordance with the law. We do assistance activities, which is, for example, what we're doing right now in Syria in relation to the populations that have been displaced and trying to get aid into Homs right now, where much of the fighting is going on. We also do prevention activities, which is outreach to civil society, outreach to the military. In my case, I'm dealing with outreach to the military. So in terms of detention is a very core aspect of what ICRC does, going back to really to the very beginning, and certainly since World War I, where we began just after that our detention activities. And so as soon as I joined the organization, which was back in 2006, they said right away, okay, Carswell, you're going to be dealing with military people, and you've got the background for that, but we need you to understand how the ICRC works. So we're going to send you off to Rwanda, and we want you to go visit all the prisons in that country and see what you think and be part of that process. So that was looking at Rwanda in 2006. We're now sort of 12 years post the genocide, and that situation. At the same time, in Congo next door, you had this General Nkunda who had taken over. He was on the verge of taking over Goma, which is right on the border where we were staying, and people were getting picked up in relation to that conflict. So you had the Rwandan conflict. You had all these so-called genocidaires, the people who had been held over since the genocide, in very austere conditions. The government trying very, very hard to deal with these people humanely, but there was a lack of water, there was a lack of food. They were getting sort of a cup of corn a day. So that's one end of the spectrum of detention. My colleagues said, oh, you went there during the glamour years of Rwanda, because back in 1995 in Rwanda, you had you had delegates who were actually picked up and crowd-surfed over to meetings because there was nowhere for them to actually move amongst the prisoners. So it's really quite amazing. And then I worked a little bit in the Indian Ocean, and there was, lots of little conflicts that go on here and there, and dealt with some of the detainee issues there, and that's where we saw some abuses. That's why I'm not naming any countries, but kind of scary to see what could happen even after we had spoken to armed forces about their obligations. Afghanistan, I was there in 2011, and working with. You had fighting forces who were coming in from Helmand province and from Kandahar province coming into Mirwai Hospital, which is in Kandahar, and they were receiving treatment after they'd been driven sometimes for the better part of a day from the fighting. These people had been fighting and therefore were a security concern to the state, in this case the state of Afghanistan rather than the U.S. The U.S. of course had its own detention facilities up in Bagram. So interesting to see people who come in with maybe they lost an eye or lost an arm, or maybe they were bleeding. But then right after that, they get picked up by the NDS and moved off into detention facilities from there. Again, you've got this humane treatment, but you also have a security concern, so it's always a balancing act. And then last year I had one visit to Guantanamo, so I got to see that for the only time in my career. I'm not an expert on Guantanamo, but I got, at the other end of the spectrum, got to see what the situation looks like there. And then finally, just at the end of last year, in November, I was in Jordan where we were talking to non-state armed groups. So these are groups who'd come down across from the border from Syria, talking to them about their obligations under the laws of armed conflict, including detention. And very difficult to have discussions with them about what to do with detainees, because anything they do with detainees is going to be in breach of domestic law. They're not allowed to detain in the first place under domestic law, and yet international law says that they have to treat people humanely. So very difficult balancing act there, but everybody agreed that that was a good idea to talk to them about the fact that they have to treat the detainees humanely. So it's a whole spectrum from American detention to very primitive.
So I think one of the key points you emphasize is that many of us in America, when we think of detention, we think of Guantanamo, but detention in armed conflict is a much, much broader topic and is going on all around the world. It's great, thank you. So Matt, how about you and your connection to armed conflict and detention?
Okay, so great. Thank you for inviting me, and it's great to sit next to somebody like Andrew from the ICRC who's so eminently qualified to talk about these things and have his views as well. I appreciate being able to be invited on this. So essentially my experience comes from working in the Pentagon, which you touched on a little bit. Right after 9/11, I was assigned there. I worked in the Air Force International and Operations Law Division. And so I had, in my assignments, I saw taskings coming from the Joint Chiefs of Staff that related to how detainees would be interrogated and other things at Guantanamo Bay, and provided opinions on that. And I can't get into all of that because a lot of that is still classified, but I will say that a lot of what the service JAGs did was not exactly in sync with what the military, or what the civilian authorities wanted to do in Guantanamo Bay. And it was essentially a good process that resulted in many of the things that were being proposed not being approved or signed off on by the then Secretary of Defense, Donald Rumsfeld. So to my knowledge, in my knowledge, a lot of the things that people argue or claim happened down in Guantanamo Bay as far as forms of coercive techniques being used against detainees were not permitted to be done by military members because of the various services, the Army, the Air Force, and other people giving input to Donald Rumsfeld on those issues, and I was part of all of that. And for at least a one-year period, I worked in his office, as you indicated, in the General Counsel's office. And there were occasions when I sat with the then DoD General Counsel, Jim Haynes, when the IRC came over to talk to us about detainee issues at Guantanamo Bay and detainees in Iraq, that was, issues that were related to them going on with that current conflict. So I had experience at that level as well. And then for a while, In 2005, I left the Pentagon, but I was deployed to this joint task force that was created. The Army was put in charge of it. It was called CITF, the Criminal Investigative Task Force. And they were in charge of essentially investigating and making the criminal cases against the detainees that were in Guantanamo Bay so that they could be appropriately processed, through the tribunal process that had been set up. And so my experience being there, and watching, I have to admit that CITF was separate and apart from the task force that was in charge of Guantanamo Bay. And it was also separate and apart from those people who were doing interrogations of Guantanamo detainees related to intelligence. So our sole purpose was prosecution. And there was a very strong mandate that we would do nothing that would be coercive in the collection of evidence because, the United States tradition is that we don't believe that information that's been coerced from a person is reliable and should not be used in a trial or a court against them. So that was a very strong mandate to us. Some of my perspective on the way that the way I feel about this comes from experience while being there at CITF. Of course, investigators were being deployed to places all over the world. They had people deployed in Afghanistan, they had people who were deployed in Iraq, and some of them were going out to difficult locations to try to gather evidence about events that had happened essentially in wartime, and these were really typically still war zones. And so what happened was there were casualties among the investigators. There were Americans who lost their lives trying to discover whether a crime had been committed. And at some point, I noticed in that organization, it was drawing back. The question was being asked, was it really worth human life to collect, some minor amount of evidence that might allow somebody to somehow be convicted and legally held for a year or two? And there was a balancing going on there in CITF as to, how much harm can we put people in for the very little payback that's really coming out of this. So there truly were American lives that were lost. My other perspective from being there was being a part of this organization, reading through detainee files, rendering opinions on whether detention should continue or whether it should not, and seeing the mandate coming to CITF from the Bush administration, which to me was in complete contradiction to what was being reported in the newspaper. Also seeing, somewhat firsthand what was going on from the perspective of CITF regarding the detainees, and then also seeing what was being reported in the newspaper. And it just, to me, it seemed to really be disconnected. It wasn't, what was being reported in the news didn't really seem to be what I saw happening within the CITF organization, at least. And of course, I did go down and participated, watched, viewed interrogations with detainees. I sat across from them in their cells. I walked around Guantanamo Bay, and so that's another perspective that I have. I have to admit that all of my experience sort of ended in 2007, so some of this I've had to go back and dust off the cobwebs about, but that's my experience.
So you raised the specter of potentially different paradigms of detention, and I think I'd like to come back to that. But first, why do you think, let's stick with you, Matt, why do you think detention is such a hotly debated topic? It's hotly debated not only in the US, but around the world. Why do you think detention is such a hotly debated topic?
Well, I can't really speak to that from the world viewpoint. It was a little bit perplexing from the U.S. perspective because, most of the wars that we are involved in involve nation states. And the rules were very clearly set forth. And it seemed to be, to people who were involved in it, it really seemed to be unambiguous what our responsibilities were and what our rights were and all of that. When we went over to Iraq, we definitely complied. The whole focus was on complying with the Geneva Conventions and not taking anyone who was detained who was an Iraqi citizen. None of them ended up in Guantanamo Bay. And when the war was over, anybody who was detained there was released. Now, there were other policies that related to people who might have entered the country who were not part of the international, the conflict, but might have been part of Al-Qaeda, and there was a different viewpoint taken towards those individuals who might have been part of Al-Qaeda coming there to take advantage of the situation. A different viewpoint was put on them, but the military didn't make those, the common ordinary soldier wasn't making decisions based upon that. Of course, when you look at Afghanistan, that was a completely different solution there. I mean, from the military's perspective, looking at the Geneva Conventions, Al-Qaeda was not somebody who was a party to the treaty. Those fighters were not complying with the law of armed conflict. They didn't have they weren't under a single commander. They weren't wearing a distinctive symbol that could be recognized at a distance. They weren't carrying their arms openly, and they definitely were not complying with the law of armed conflict. And so from the perspective of the United States, we knew our military members wouldn't have that protection. And our international obligations just clearly didn't seem to indicate that the Geneva Conventions would apply. Now we did, and we still do say that Article 3 of the Common Article 3, which is in all of those Geneva Conventions, the one that provides humanitarian treatment to anyone, that those did apply, and we promised that we would abide by that.
So Andrew, what about you? Why is this such a hotly debated topic?
I mean, it's hotly debated because when you have an armed conflict or even other situations of violence, states of emergency that don't amount to an armed conflict, you have the state in a precarious position where it's defending its own existence to a certain extent. I mean, the pendulum is very likely to swing into the side of state sovereignty and into a security state, a lockdown state. That's recognized, first of all, by the fact that you have a law of armed conflict specific to that context. It's also recognized in international human rights law, which says that in states of emergency and where certain prerequisites are met, you can derogate from certain human rights. For example, you can hold somebody maybe for a week rather than just for a couple of days without a trial because there's an understanding that the state is in trouble. So what we're trying to find is this balance between these principles of military necessity on one side and humanity on the other. And all of the discussions that we have about detention and beyond that, even about the conduct of hostilities and armed conflict, it really comes down to the friction point between those two. I often say when we're talking to our U.S. JAG colleagues, the lawyers in the armed forces, I think it's fair to say that if I agreed with everything that they did or they said and vice versa, neither of us would be doing our jobs. The ICRC is going to come at it from the perspective of the protection of the civilian population and from obviously the absolute humanity of circumstances in detention. And the military is going to come at it from the perspective of, okay, we have operational requirements that need to be taken care of. We have intelligence requirements. We have to, when it comes to conduct of hostilities, we have to take into account the fact that, yes, civilians are part of the equation, but what about our own troops and their safety? These are all legitimate considerations. So invariably they come into friction. So a big part of our job is really to decide, where we can agree, and then now here are the gray points, and let's work on them constructively rather than having vitriolic debates, which it seems we don't have anymore. But it was perhaps more the case shortly after 2001.
Well, you raised this fact that these ideas come into tension. I mean, we picked the title for this panel to be, the U.S. versus the world in terms of detention and armed conflict. Is there really a bifurcated view of the U.S. and the world? And it seems that we, at least in the press in the United States, get a lot of harassment from other nations across the world about how we detain both in Iraq and Afghanistan and in Guantanamo. Is there really a divide, Andrew?
I think today there's not a huge divide. I mean, in the sense, the issues that we have with the U.S. As ICRC are the same issues we have worldwide. Perhaps what makes the U.S. different is the fact that you have this breadth of exposure worldwide. You're in the most conflicts worldwide. You have a global reach, which, I come from the Canadian Armed Forces. We just don't have that. It's a totally different context. So if you look at it from that perspective, there's more of a surface area to have these discussions. There's going to be more critique and so on. I found myself in a lot of contexts sitting in front of audiences in Southern Africa where people are criticizing the U.S. and I was saying, well, okay, that's fine. What about yourselves? I can do that as a Canadian, right? So play them, let's look at what you're doing as well. And it's not all about the U.S.
But as you admitted at the first, if you take an objective view, the U.S. is at least doing better than many of the countries where you've done your work. I often hear U.S. folks say, why doesn't the ICRC focus on the problems that exist out there?
Okay.
Because we're doing pretty good.
Well, I'll give you one example. I mean, if you take the authorization to use military force, the AOMF debate, this comes back to the qualification of the conflict between the U.S. and Al-Qaeda and associated forces around the world. That's a perfect example today of where we're debating the issues with the U.S. because the perspective of the government right now is a legitimate one, and we've got a counter perspective. But their perspective is that wherever Al-Qaeda and their associated forces find themselves in the world, that is an armed conflict with them. And the ICRC is consistently taking the position that you have to look at the individual conflict, the individual country rather, and say, within that country, have you met the prerequisites of an armed conflict? So in other words, if you're talking about non-international armed conflict, which is mostly what we're talking about today, you're talking about there has to be an organization of the parties, there has to be intensity of the hostilities in that country, and if you reach those things and you have an armed conflict, then it's understood that you can apply the laws of armed conflict. But when it comes to, for example, a country, an Al-Qaeda member, let's take a hypothetical example. An Al-Qaeda member is sitting in Mauritania. He's recently been fighting. He's recently been fighting in Mali, but now he's in Mauritania. Maybe he's visiting his family. He's unarmed. He's in a context in which nobody's fighting. ICRC is saying, okay, go in there, and maybe you have to. If this guy is a threat to the U.S., maybe you have to actually go in. First of all, you have to look at the jus ad bellum issues. You have to look at the UN Charter issues, whether you're allowed to go into Mauritania. But once you get past that, you then should be taking some risks to grab these people, snatch them, and pull them out, rather than striking them with a drone, for example. Whereas if that were to happen in Yemen, we wouldn't object to the use of drones because we would say that the U.S. has joined an armed conflict that's pre-existing in Yemen. So it really depends on the country. But if you take a global approach of wherever they find themselves, that's an armed conflict, then I think you find yourself in issues. So detention really, we're trying to promote more detention, less targeted killing in those limited contexts, but we're not excluding targeted killing either I don't like that terminology, but the use of military lethal force in cases where you have an armed conflict.
But in your hypotheticalized situation with the Al-Qaeda person, if he was detained, what would be the detention paradigm in which he would be put?
Well, if you're, say, for example, in Mauritania and you pick somebody up as a threat to the state, then you're going to say this is in relation to the Mali conflict, and so you have to then look at who the players are in that particular conflict. So in this case, you're talking about somebody who's of interest to the actors in Mali. It could be including the French forces, could be including the government of Mali, and so on. But the detention aspect should be coming through that country, and if the U.S. are supporting that, that can be justifiable as well, no question. But the paradigm is armed conflict beginning in Mali that's now had somebody leaving that, and you're bringing them back in, detaining them because they represent a threat. And ICRC has always taken the view that internment of detainees who represent an ongoing threat is possible, but subject to procedural safeguards. And that's the difficult point, is the procedural safeguards issue.
So, Matt, Andrew would say that once you've classified a conflict, everybody who gets detained within that conflict gets basically the same kind of paradigm applied to them. What about subdividing that? Why not say, well, terrorists get one detention paradigm and soldiers get another detention paradigm, and understanding that there's a difference between POWs and non-POWs, but why not divide these detention paradigms much more into many more subcategories? Why wouldn't that be an effective approach?
Well, I probably agree with that. I would agree that there needs to be a different paradigm for people who are terrorists versus people who are part of the military of a country. I would tend to disagree with the idea that once you're involved in some kind of an armed conflict with someone other than a state agent, that it limits the way that you can approach that. Because I approach that issue from the perspective of states' right of self-defense, which is, in my viewpoint, can't be imposed upon by international law. You have an unalienable right to defend your country, and if someone's declared war and they're taking hostile acts against you, and they're an enemy combatant against your country, and you have the right to protect against that. And I feel like some of the things, I don't mean to be critical of the ICRC, but a lot of the things that happen in the international community have really created problems, because the Bush administration, when I was there, they wanted to do away with Guantanamo Bay. They wanted to get rid of the detainees. The order that came down to us was, get rid of as many of these people as you possibly can. And they were negotiating with foreign countries that I can't mention, that they were trying to repatriate their own citizens. And those countries were in private negotiations giving us the stiff arm, saying they wouldn't take their citizens back. And then publicly to the newspaper, they were condemning the United States. So most of the detainees that I think have been released were released under the Bush administration. And it was my position and view that even though Obama, part of his campaign speeches was that he was going to close Guantanamo Bay, to me, I knew it wasn't going to happen because it was just, there was no place for these people to go. And if you look at the kind of people who are down there, the kind of behavior that they're involved in, they're almost like, many of them who are still there are like the worst of the worst in our criminal lockups in the United States. They throw urine, they throw feces, they do the kind of things that a high security detainee, somebody who has been convicted of a crime in one of our high security lockups would do. They came from failed states, states that didn't have adequate criminal law provisions, ways to incarcerate people who are doing criminal activities. And the United States had to go out, I mean, from my perspective, the United States had to go out and clean up this international mess. We would like to get rid of those people, but we're not going to just set them free. Certainly, you take a look at countries like Saudi Arabia who moved in, it created kind of a rehabilitation process, and it took its citizens back, rehabilitated them, and let them go. One of the bad things that I see is all this pressure and criticism of the United States and what they've been trying to do in Guantanamo Bay. They've done everything they could possibly do to try to treat people humanely, to release people, to do negotiations, to let go of people. The Canadian who was down in Guantanamo Bay was eventually turned back over to the Canadian government. I mean, you can have criticisms both ways about what happened there, but America doesn't want to detain people. It doesn't want to torture people. As a whole, our country believes in a lot of the principles that the ICRC believes in. But the criticism now arguably has created a situation where we don't go in and detain people. Instead, we go and send a missile in because we don't want to bring them back to Guantanamo Bay. We're through with the criticism.
Yeah, and that's a difficult issue right there, whether the detention policies make it too hard to detain. And I know that Andrew, you and I have talked about that in the past. I put words in your mouth with that last question to Matt. Do you want to respond to any of that?
Well, just one thing I wanted to say is I mean, in relation to this concept that there are threats to the United States and they have to be dealt with, I couldn't agree with you anymore. And I guess we're not in any way trying to detract from that reality. I guess what it comes down to is there are risks that an armed force can take in order to do so in accordance with the appropriate context. If you want to put it down to one principle, it might be the principle of equivalency of belligerence. It effectively means equivalency of arms. So the idea is that if you have somebody in a situation in which they're not armed and they're not in a situation to defend themselves, then you should be trying to pick them up in a way that's something short of lethal. And so that to me is one of the crucial points where we stand today.
But from the perspective of the guy that has to go in and do this, it's easy for you to say that. But when you put yourself in harm's way, you may think he's not. What the international community has expanded the view of combatants and set under the protocols of the Geneva Convention and says, well, you don't have to perfectly meet this idea of carrying your arms openly. You can be among the population as long as you come out with your arms, as long as you have some kind of identification, then you can still be considered a combatant. So, you go into a situation thinking that it's completely non-hostile and then you're ambushed and killed. So from the perspective of the person who wants to go in and do that, weighing the balances, we want to come in completely in a way to totally protect ourselves. Why should we have to give up our lives to detain someone who is a hostile threat to us just because he may be acting as if he's not a hostile threat?
Okay. Well, and just to clarify, on human rights law, as it's applied, or even the if you want to call it the customary law of self-defense, too, does allow you to use lethal force. But if you're in a situation that's not an armed conflict, it would say you're only using lethal force in response to a direct threat to your life or to the life of another. It has to be imminent as well. So some people think, okay, are you asking us to be bobbies, swinging around batons? And we're saying, no, you're more like a SWAT team in that situation than a bobby. But you have to wait until there's a threat. If somebody's armed in a situation that falls short of an armed conflict, there's every reason to use lethal force against that person in certain situations. So I think it's just a question, really, sometimes of sitting down. The difference with the law of armed conflict framework is that in that framework, of course, you don't have to ask any questions. You have a status-based individual who's a member of a declared hostile force, who's a party to an armed conflict. You can use a bullet in the first resort, and it can be a bullet sent right down the middle. And that's a very different paradigm from the policing one, which I'm just discussing. And if we go into this with clear eyes and know fully what the rights are within those frameworks, we can have that discussion. But when it comes to the U.S., it can be difficult because the U.S. doesn't agree with officially doesn't agree with the extraterritorial application of human rights law. And we heard Harold Coe from State Department at the time talking about how there might be a move towards that recognition of that, but it never quite got there. So we're a little bit in limbo in talking about those rights, and then we talk about self-defense instead. But that's all at the political level, policy level. And what I see in terms of working with armed forces is something much more pragmatic. You've got operational orders, you've got rules of engagement, and actually those very effectively address these issues probably better than we think. Like, for example, you already have a self-defense paradigm in your conduct-based rules of engagement. You already have a law of armed conflict-based paradigm in your status-based rules of engagement, and that might be actually more reassuring than all the politicians put together.
So many of you will have recognized this debate that they're entering now is the debate, a current debate that's very hotly talked about this, whether you have to detain in certain circumstances or whether you can use lethal force all the time. And it's a very hot and ongoing debate, I think, even now. I would like to save as much time for you as questions, so if you want to start lining up, let me give them one more question to chew on while those of you who have questions are lining up at the mic right there. When you do have a question, please tell us who you are and your affiliation. So let me give you this question while we're waiting for the audience to get ready, and that is, what do we do with Guantanamo then? We know that President Obama has said that the fight in Afghanistan is going to come to an end probably this year, given the fact that there may not be an agreement. When the U.S. forces are out of Afghanistan, what does that say about detention for people in Guantanamo who were detained in connection with the conflict in Afghanistan? And Matt, maybe we'll start with you.
Well, ordinarily, if this was an armed conflict between two states, at that point there would be a negotiation and these people would all be released back to that nation state. This is a little bit touchier situation going on here. I don't know that that Afghanistan wants to take these people back. If the U.S. felt, I'm sure if the U.S. felt that they would be adequately dealt with, that they wouldn't become threats to the United States, I think we'd want to give them back to Afghanistan. But that situation there is so tenuous that the question has to come up in people's minds. If we send back these dangerous people to that state and there's still terrorist activity going on there, we don't know whether the government will survive. Is this really what we want to do? Because these people are still our enemies, and they're sworn enemies of the United States, and the war really isn't, the greater war still isn't completed, which is the war with Al-Qaeda. They're still continuing to attack us. We've had attempted attacks in the United States on aircraft, people who claim to be associated with Al-Qaeda doing other forms of attack, like at the Boston Marathon.
But what about a Taliban detainee who was picked up with the Taliban?
A Taliban detainee.
I mean, Afghanistan may not want him back, but once U.S. forces are out of Afghanistan, isn't that conflict with the Taliban over?
Well, what does the U.S. do if Afghanistan won't take them back? What do we do with them? Put him on a boat and give him a couple months worth of supply and say, go ahead.
I don't think Andrew would recommend that approach.
It's kind of like a catch-22 that you put anybody in the United States in. What if the country won't take them back?
But do you accept as a matter of law that the U.S. would have to release them if they could?
If they could. if they could release them back to authorities in their own country, I would say that the United States would have to do that. And I would think that they would. I would see no reason why they would not do that.
Andrew?
So, yeah, I mean, I think Matt and I agree on that. And I mean, I think that the way, if I could go back in hindsight and relive the whole thing and be part of the decision-making at Guantanamo, which is obviously pretty fantastical thinking, you go back and look at first principles of law of armed conflict again and maybe say, okay, in 2001, 2002 in Afghanistan, you had a law, you could make it into a law school exam, really, because you had every kind of detainee at the same time. You had ICRC would have said, and continues to say, that the Taliban were the government of Afghanistan at the time, de facto. They weren't recognized. They weren't not a liked government, but they were the government. And they were there for the armed forces of the state. And if they were taken, they should by that be treated as prisoners of war. Others, that's now an international armed conflict. And flowing from that, you have individuals who would then be held under the 4th Geneva Convention, which is anybody other than a combatant can be held under the 4th Convention if they represent a threat and subject to review every 6 months. So even if you have a member of Al-Qaeda, suddenly you've got and he's not a combatant, he doesn't meet all the requirements, as Matt was rightfully saying, then that individual could be detained as a threat, subject to periodic review, but the presumption would be of release. But you can rebut that presumption, of course, if he represents a threat on an ongoing basis. That means you could hold him for a very long time. For the Taliban member, you can hold that individual right to the end of the conflict. So in this case, we'd be talking about 2014, and now he's out. At the same time, you had a non-international armed conflict going on. You had the Northern Alliance that was fighting, later on, they were fighting with the coalition forces, but they were fighting against the Taliban. So you had a non-international armed conflict between what was the de facto state and a non-state armed group, and they were governed by Common Article 3. So then you got another group. And then you've got those who are being interned under non-international armed conflict, and then you've got those who are being prosecuted. And they can happen simultaneously. You can intern somebody and then eventually prosecute them. And then you've got general criminality going on at the same time, people stealing stuff. All of this is happening. I've just named what I think is 5 categories, but you could even break them down further. If you're able to retrospectively, and again, we're much more developed in the way we discuss these things now than we were at the beginning of of this millennium, then we could go back and do it all exactly perfectly. But I'm not sure in terms of the practical things that Matt just mentioned that there's not, that I can actually offer a whole bunch of great alternatives as to what to do now. In terms of repatriation, there are some very practical issues. In terms of the treatment, everybody agrees that the treatment today is humane. We can talk about on the perimeter. I mean, things have really drastically improved in the last decade. And so we've had a really good dialogue. And we're not saying that we're responsible for that. It's a confidential dialogue that we have with all the states. We'd like to think that we were part of that. But it's the U.S. government that's done a lot of good of its own volition. And so, yeah, there are things that can be tinkered and played with. But eventually, when it comes down to this macro issue, which is, again, this definition of where the armed conflict is, that tells us when you can repatriate. So as you're suggesting with Afghanistan, it's the end of the conflict there. It's time to repatriate. If you've got somebody from Yemen, then you'd have to look at that particular context and so on. Guantanamo is confusing because it's a particular place that's very far away from those conflicts. But really, you have to take that individual, ask where were they picked up, what was the context, and apply the appropriate law. And as I said, it's not like that's not being done. It's just, and sometimes there are disagreements on policy, but it's all moving in a positive direction.
Well,
so,
can I just
so
make one comment
of course,
to that when you're done? I don't mean to
no,
interrupt
please,
you.
go ahead.
One of the problems is, especially, in Iraq, it was fairly easy to distinguish the different categories of people and where they should be, But in Afghanistan, it was impossible. Everybody wore the same clothing. And all you saw was somebody, concealing a AK-47 or shooting at you. So if you detain that person, you don't know which category he goes into because these people aren't complying with the general rules that we would ordinarily see. So it takes a lot of time to figure out or to make an argument. Was he part of the Taliban? Was he part of Al-Qaeda? How do you distinguish that? And then how many American lives are necessary to go out and figure that out? Why do we have to sacrifice American lives to figure that out or to determine that? I mean, can't we just, there should be clear enough rules, and if a soldier is there, it ought to be, he ought to be able to act in self-defense, and our country ought to be able to act in self-defense without, we shouldn't be penalized because someone else is not complying with the law of war.
Well, you know, there's an article in the Third Geneva Convention, it's the fifth article, which says that if you don't know, presume they're POW, and then sit down and have that determination, have status determination reviewed. And that means bringing in all the intel you've got. But that's been understood. You know, that was the sort of thing that was done in World War II when you had all kinds of strange non-state groups around. This is something that was done in various conflicts since that time, and I think it can be done. But you know, if we don't want to end up in a situation where everybody looks the same, if you've got a weapon, that means you're trouble. Well, it could be you've got a weapon because you're protecting your family. It could be you've got a weapon because you spontaneously participate in hostilities, in which case you're a criminal issue. Or it could be somebody who's now effectively joined an armed group, in which case you can treat that person as a member of the armed opposition. But that's the reality. And when you talk about, you know, this provision in addition to Protocol 1, which the U.S. disagrees with, it basically says that anybody who carries their weapons openly during the deployment phase, during the return from hostilities, during the execution, that individual is considered as distinguishing themselves. The U.S. has always said, no, you have to have a uniform and fixed distinctive sign, and that's fair enough. But also in fairness on the other side, almost 90% of the countries in the world agree with that provision today since 1977. And it was a reaction to the wars of the 1960s, the post-colonial wars, the Vietnam War, and so on, that was the reality of conflict. And if we went with a pure uniform basis, then everybody becomes sort of an unlawful combatant. And that's our concern, is if everybody becomes an unlawful combatant, then...
Well, you know, from the U.S. perspective on that, we did do the initial screening of people in Afghanistan, and of course it went on and on. But I mean, when everybody's a honey salesman and is over in Afghanistan trying to pick up honey, and you know they've all changed their clothes and they've thrown their weapons away, it's kind of hard to distinguish between whether they're Taliban or whether they're Al-Qaeda. I mean, I couldn't tell, and I had my eyes on top secret and everything else that there was to see on it, and even that. I mean, you can argue it's not the kind of evidence that we would want to use in a court of law or something, because this was evidence that's coming from a battlefield with hearsay and not reliable witnesses and all of that.
The thing about a status determination tribunal, though, is you don't have to have a standard of perfection there. It's not a trial in the D.C. circuit. It's a field trial done by the military that's detained, and it can be done by a couple of officers. We just have to determine based on preponderance of evidence they have, and that's all we can ask.
Still hard.
Very difficult, no question about it.
All right, so audience questions. Heard now about detention. What are your thoughts? Corey, are you moving to the microphone?
Yeah, that's right.
All right, go on then. Introduce yourself and then ask your question.
Corey Chipman, undergraduate, European Studies major, minors in business and Scandinavian Studies. I'm an editor right now on a paper on the ICC and its ability to detain, actually, and how that ability to detain is, I guess, blocked by its lack of kind of authority in these situations where you've put out an arrest warrant but have no way to actually bring someone in. I believe 18 people are under prosecution right now, but only 5 people are actually detained. How do you deal with that situation when you have no ability to actually go in and detain someone, even if you have the ability to, you've got the facilities to keep detainees, but have no authority to then detain?
Question. Andrew, you want to take a first swing at that?
Sure, first shot at it. I mean, the ICC was developed in a sort of a horizontal construction in the sense that it's really the Rome Statute's a treaty, and either you buy into it or you don't. I think it's 110 or so states parties out of 193 UN members. So a good chunk of them, but there's a lot of places where people can go and get away from the jurisdiction of the court. And there's some high-profile examples, and even some countries will not go after heads of state for reasons of policy and so on. So it's very, very difficult, whereas if you compare that to the Yugoslav tribunal going back to the 1990s, you had a much more vertical structure where it was, the tribunal was created by the Security Council, and so the Security Council could back it up and could get its claws into it. So maybe it's a question of engaging Security Council to assist the ICC in these warrants, but I don't think that's really feasible either, because there's a lot of disagreement between, I mean, the permanent members have not, in large part, signed up to the ICC. You have France and you have the UK, but the others have not signed up. So I think what we're looking at is the real the intersection of international law with politics as this area is, it makes it really, really difficult. But if you've got an arrest warrant sitting over somebody's head and one day they get picked up, and we saw what happened in relation to the Special Court for Sierra Leone and the Charles Taylor trial. He wasn't expecting to get picked up in the country where he was picked up. And next thing you know, a head of state was brought before the court. So it can happen. And when you compare that to the decade prior to the ICC and then going back historically, it's phenomenal that something could happen. But granted, there's some huge cracks in that system.
Even in situations, Corey, where the UN Security Council refers someone to the ICC, they still don't then work together and provide the power to detain. So I think that's a great question.
Yeah.
Thank you very much. Daniel?
Thank you so much for coming and speaking. My question is about the U.S. Yes, I'm Daniel from the law school, yes. You said my name, so I just didn't think I'd repeat it. So my question concerns the practice of extraordinary rendition and the use of black sites that the United States used or either used or currently uses. I guess I'd like to hear the legal justifications for the use of rendition, and then if, according to the ICRC position, there's any instance where that would be justified or whether that would be proper to use.
Well, Matt, let's start with you then. What is this the U.S. is doing?
That really, I have no knowledge of that. And I was never part of a discussion related to that. It wasn't something the U.S. military was involved in doing. So at least not to my knowledge.
So let's assume from the newspaper articles that it has been happening, and even if it's the CIA who's doing it. Should the U.S. have lawful authority to do that? Should that be something that the U.S. can do? Should we be able to detain people in that way?
Well, I think it all goes back to this question of self-defense. And it would depend on whether or not there was adequate need to do something like that to defend the United States, if there was adequate justification of imminence of some kind of threat against United States citizens. But yeah, I think that there are situations under which it could totally be justified, because under most international law, you don't have to sit there and wait for the nuclear missile to come in before you try to defend against it. And the United States for a very long time had a policy that they would not rule out first strike with their nuclear weapons. In fact, to my knowledge, that's never even been changed even today. We reserve the right to do a preemptive strike even with our nuclear weapons.
But if you have this person detained, why not detain them openly and under public review as opposed to in some place where it's unknown that they're being detained and their treatment is not monitored, et cetera?
I don't have an answer to that. I've not really been totally involved in it. I haven't thought that through very well, so I really can't defend that.
Andrew, I'm sure you can attack it.
Well, I mean, it's one of the basic principles of international law is because so much of this stuff comes from Europe. It had to be a French term, non-refoulement, they call it. Non-refoulement is just I mean, it's a simple doctrine which is a non-derogable right of obligation rather of international law. It says that you can't transfer somebody to a country where there's a reasonable suspicion or reasonable grounds that they're going to be ill-treated, if you want to just break it down to brass tacks. And you've got the Convention Against Torture. You've got a number of different things which apply here. Is moving somebody just away from your territory against the law? No, I mean, the Third Geneva Convention is actually silent on the issue. In the Second World War, you had prisoners of war who actually moved to South Africa, for example. I mean, there were good reasons to move people out of the conflict in order to ensure that they wouldn't escape, but also they could be humanely treated and kept away from the battlefield. So there's no problem in certain situations. The Fourth Geneva Convention is different. I don't want to get into all these nuances, but it can happen. But obviously, if there's going to be any kind of ill treatment, then that runs against pretty much the gamut of international legal protections.
Okay, thank you, and thank you for that question, Daniel. I think our time is up. If you'll all join me in thanking our panel members. And thank you all for coming. We appreciate it.